Hello and welcome to Beyond Launch TV. I am your host, Attorney LaConya with Off the Mark IP Solutions, where we help clients throughout the United States with trademarks, copyright, and business development solutions. Over the last week or so, I had the privilege and opportunity to speak to two amazing group of ambitious and determined, motivated entrepreneurs just like yourself. And through those talks, one of the main things that came up was, how do I protect myself when I'm working with third parties? Great question, which is why today on the launch talk is focused toward the 4 top contracts every entrepreneur needs to have in their arsenal. Are you ready? Let's begin. 1. The first contract you need as an entrepreneur, I would say, is a client retainer agreement. Your client retainer agreement is the agreement that is between you and the person that wants to retain your services. And the reason I say that that's number 1 is because it details and explains exactly what services you're going to provide, and in most cases, or in some cases, it details what services you will not provide. The reason you want this agreement is so, first of all, we're going to get away from the handshake deals and the oral agreements, because although oral agreements are enforceable, what happens is you make the contract while you're both in love, while you're both happy and excited to work with one another. But down the line, if there's a misunderstanding, you might remember things differently. If you put your agreement in writing, what services you're going to provide, what services you're not going to provide, you won't have any misunderstanding. And make sure your client retainer agreement includes things like the name of the parties, payment terms, responsibilities and duties, and time for the services to be complete, just to name a few. Number 2, the second agreement I think that every entrepreneur needs to have in their arsenal would be I would say the next one is going to be your joint venture agreement, or either joint venture agreement, or if you're working with someone, a partnership agreement or operating agreement. These agreements, no matter, it really depends on what type of organization you're going to form. But the reason I say the joint venture agreement is my number 2 is because right now we're living in the world of collaboration over competition. We have a lot of people that are working together. They're pulling together not only their resources, but also their reach by being able to go into one another's like things like email lists and target market, being able to pull them and bring those resources together. Well, what you want to do is you want to have an agreement. You want it to be fair. And again, the whole purpose of written contracts is so that you can memorialize your understanding. It's nothing worse than working with somebody that you feel like they're not pulling their weight. But I think you can avoid all that by having your agreement and having a conversation beforehand. Because that's one thing that contracts make you do. They make you have a conversation. You can't just write this contract up without talking to the other person. And if you do, when they read it, they're going to say, hey, this is not what I understood it to be, or hey, can we add this? This is what I expect out of the agreement. And while some people are intimidated by that, those are really good things to have and talk about and hash out in the beginning. Because like I said, there's nothing worse than working with somebody and getting halfway through it, or getting towards the end of it, like, you know what, I would never work with that person again. They didn't do X, they didn't do Y, they didn't do Z. But the other person never knew that those were things that you were even expecting from them. So the second agreement I would say is your joint venture agreement. And if you can't tell by now, one of the main things that your agreement needs to focus on are the responsibilities and duties of each party. The second thing I would say that it needs to talk about is payment. How are you guys going to split the fees? Another thing, a lot of times when you're having events, whether it's an offline event or an online event, such as a webinar, you want to, especially if it's a paid webinar, you want to discuss up front if you're going to give away any free slots. Because you hate to have a paid event and your partner or yourself say, hey, you know what, I'm going to invite 5 of my buddies in for free. That's 5 seats that could have been sold. So if you're going to invite 5 people in for free, do those 5 people go against your cut? I don't know. Let's talk about it. Okay? Number 3. Now that we talked about your relationship with your clients and your relationship with your partners, what you want to talk about now, what about those relationships with third parties who might not be so close and have intimate relationship with your business, but you still need them in order to further your business? A lot of times what people are afraid of is they have intellectual property, whether it's trade secrets, their trademarks, their copyrights, or just some other intimate detail that they don't want anybody to know. But some people have to know in order to bring that vision to life. Okay? So how do you work with those people? The main thing that you can do with those people, well, first of all, let's say this. You need to limit your communication with people. If they don't need to know, don't let them know. Don't go around telling everybody your business. The second thing you need to know is just let them know exactly what they need to know in order to get the job done. If you're working on a project and you only need this person over here to make the tops, there's no reason why you should be working and talking to them about your entire plan and your marketing plan and your customer list and all the other details of this project. They just need to know about the tops. What do you need in order to get the tops done and produced? That's what they need to know. But in order to protect yourself in these communications and make sure that what you tell them stays between the two of you, you want to use a confidentiality agreement, or a non-disclosure agreement is also known by. And what that does is it limits the other person. It lets them know up front that, hey, I'm talking to you about this, but I want you to know this is proprietary information and you cannot let it leave this circle. And if you do, there will be legal consequences because it will harm my business. You're letting them know this up front. If you haven't learned, we have a theme for today. That theme is upfront communication. There's no need or no reason to have anything be a surprise when you're working with someone. Working with someone successfully, I don't care if it's your client, your partner, third-party vendors, whoever it is, it really requires you being upfront and having open communications. I know some people are intimidated by having communications and because they feel like, well, if I let them know, maybe they won't do it. Okay, maybe they won't. But isn't that a good thing? Wouldn't you hate to get into an agreement and enter into a relationship with someone where you're expecting the moon and the stars and they have no intentions of giving it to you, but you still go into the relationship hoping that they're going to give you the moon and stars? Wouldn't you like to have this conversation up front with them, tell you, you know what, I'm not giving you the moon and stars. I have no intention of giving you the moon and stars, and if that's what you want, you need to go somewhere else. Wouldn't you rather have that conversation versus working with someone for months and not getting what you need out of the relationship? And so that's why you have this upfront conversation. Don't let fear and intimidation stop you from handling your business. And if you work with someone who's like, you know what, I don't want to sign a contract. We can just do this up and up, No, it's business. And you can let them know that, you know what, I trust you. I want to work with you. But at the end of the day, I need you to sign a written agreement because this is business. And if you're working with someone that's in business who doesn't want to sign a contract, you might want to question why they don't want to sign a contract. Because most people in business understand that written agreements is just a part of business. I don't care if you're friends, I don't care if you're family, I don't care if you're strangers, you want to have a written agreement. So the first agreement you want to have is your client retainer agreement. Your second agreement you want to have is your joint venture agreement or your operating agreement if you're going to join a partnership with an LLC, or your partnership agreement. The third agreement you want to have is your confidentiality agreement. And then your fourth agreement is your virtual assistant agreement. Virtual assistant agreement, Connie, what's that? Let me just tell you, technology is amazing. I love technology so much. I love the ability to be able to work with someone across the United States or across the world to get things done and them not being in my space. I like the ability for me to work what I'm working on and to be able to delegate what I'm not good at. And one of the things that makes that happen for me is the use of virtual assistants. And I do use virtual assistants, but one of the ways that I found to be successful, again, what am I going to say? Y'all probably already know what I'm going to say. Communication. Communication is key. But in this case, what I found, one of the number one complaints that I hear from virtual assistants is when it comes to working with people, is that we don't know how to communicate to them what we need. And so what you want to do is spell out and have a conversation before you even hire them. This is what I'm looking for. Can you do X, Y, and Z? This is what I'm looking for. This is how I want it done. This is when I want it done. You need those things in your agreement. Your virtual assistant agreement also needs to include some type of intellectual property assignment. So if they're creating something on your behalf, you want to own the right to that intellectual property. So that's 4. And speaking of intellectual property, I'm going to give you a bonus. We like bonuses, right? I'm going to give you a bonus. Today's bonus is, so the 5th contract I would say that you would need is a copyright assignment agreement. Over the week, this past Friday I did a talk in Birmingham. And we were talking about trademarks, and we just barely got into copyrights before the session was over. It was such a great session, oh my goodness. But one of the things that I always tell people is that when you're hiring a third person to do your work for you and they create that work for you, if they're not an employee doing the work in the scope of their employment, that work belongs to them. I don't care how much you pay them. I always tell people that just because you pay for it doesn't make it yours. So just because you pay someone to do your logo, at the end of the day, if there's no copyright assignment, then they own the rights to that. So what does that mean? That means they can limit how you use and what you do with that logo. That means they can take that same logo and give it to someone else. Why? Because it's theirs. They can do what they want to with it. And so what the copyright assignment does is transfers all their interests and rights from them to you. And you'll be surprised how many graphic designers don't even know this. But this is a conversation that needs to be had in the beginning, and this is something that you need to have in writing so that you can go on to register your copyright with the U.S. Copyright Office. All right, so there we go. I gave you not 4, but 5 top contracts that every entrepreneur needs in their arsenal. So if this is a contract, if you don't have this in your contract arsenal, don't worry, no worries. You know I got you, right? You can go over to 30daystoLaunch.com and click on Document Bank. First of all, let me just tell you about 30daystoLaunch.com. It is an amazing resource for business owners and entrepreneurs. If you're new to business, if you've been in business for a while, if you're an entrepreneur, definitely go check out 30daystoLaunch.com. You will find our Business Basics Handbook, our Business Plan Workbook, an array of courses covering trademarks, copyright, and business basic and fundamentals. You'll also find our Document Bank. And our Document Bank is on and popping. Let me just tell you, you're going to find our most popular contracts available as templates for purchase. So if you want these contracts and you don't quite have the funds to retain an attorney to draft up a contract for you, we got you. Okay, you can go to 30daystoLaunch.com, click on Document Bank, and you will see an array of contracts there available for purchase. And the best thing about these templates is that you can use them over and over and over again. And because we love ands and bonuses, they come with an instructional video. An instructional video that teaches you how to use that contract. It walks you through how to complete that contract. Okay? So that's all we have for you today. Thank you so much for joining us today on Beyond the Launch TV. Make sure you check out our website at Off the Mark IP Solutions. Make sure you check out our shop at 30daystoLaunch.com. Like us on Facebook, follow us on Instagram, and we will see you next time.